One of the things that's happening in the market is that in the old days, when you got named as additional insured, you got additional insured protection. You were an insured under the policy and you got everything under the policy except contractual liability coverage. Nowadays, there are a lot of restrictive additional insured endorsements that basically say, yes, you're an additional insured, but only for your vicarious liability for the negligence of somebody else, or only for your concurrent negligence, not your sole negligence, or only for current operations, not completed operations. And in addition, there's what I call a lesser than endorsement that basically says you're an additional insured, but only for the lesser of the policy limits, which is fine, or the minimum limits required by the contract. And the problem there is that minimum limits are the minimum threshold that it takes to be able to work on a particular project. So they're set to catch the lowest possible person in terms of insurance coverage. Most of the quality contractors would be expected by the operator to have significantly higher limits than the minimum. But these additional insured endorsements say that you're additional insured, but only for the minimum insurance limits required by the contract. And this can be a terrible trap for the contractor as well, because it's not unusual to have a provision that says that the operator's an additional insured, the operator group's an additional insured on all policies, whether or not required by the contract. And if I'm involved, I say to the full limits of each such policy. Well, if you do that and you have that provision, then there's an interpretation question as to whether or not the additional insured endorsement cuts it, because what does it mean by minimum limits? Does it mean the minimum limits that you had to have to get on the job, or does it mean what you were required to give somebody as additional insured coverage? If the court finds that the obligation to give full coverage was enforceable, but the endorsement restricts coverage, then it's the contractor that has the gap and has uninsured exposure between the minimum limits and what it promised to give.